until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy, an institution that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. But are we to nullify an election on the basis of a last-minute boardroom rupture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50+1 of all the votes cast in accordance with Article 138 of the Constitution. The first, second, and third petitioners averred that the first respondent did not garner 50%+1 of the total votes cast, and therefore did not meet the threshold provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50%+1 of the votes cast, this ought to be calculated based on the total number of votes cast, excluding rejected votes. They argued that 50% of 14,353,165 votes, in their view, were the valid votes cast, which amounted to 7,176,582.77 votes. They therefore contended that by attaining 7.176,141 votes, the first respondent did not meet the constitutional threshold to be declared president-elect. Supporting the claim that the first respondent did not meet the 50+1 constitutional threshold was the 6th petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IEBC after the official closure of voting on 9th August 2022. According to the 6th petitioner, the chairperson of IEBC announced that the voter turnout was 65.4% of the total number of registered votes based on the verification of the KIMS kits which were functional during the process of voting. In addition, the sixth petitioner urged that the voter turnout of 65.4% did not include some 238 polling stations where the KIMS kit and malfunctioned, necessitating use of the manual register. It was therefore urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, that this number was bound to increase once the number of votes from the areas that used the manual register were included. The sixth petitioner further claimed that a summation of the minimum number of votes cast and unturned manual votes would represent the actual voter turnout. In challenging the declaration made by the chairperson of IEBC, the sixth petitioner affirmed that the final tally, published in Form 34C, only accounted for 14,326,641 votes cast, including some 113,614 rejected ballots. The sixth petitioner contended that this tally did not factor in some 140,138 votes cast using the manual register. The sixth petitioner computed this number by subtracting 14,326,641 declared votes cast from 14,466,779 generated by the sixth petitioner as representing 65.4% of the voter turnout. Referring to the tallies in Form 34C, the sixth petitioner summed the number of votes cast for each candidate as follows. Raila Odinga, 6,942,193. William Ruto, 7,176,141. Wahiga Mwaura, 31,987. And George Wajakoya, 61,969, adding to a total of 14,213,027. He then added 140,138,000 arranged to be unturned votes, and this yielded a total of 14,353,165 total valid votes, which the sixth petitioner used to compute the percentages garnered by each candidate as follows. William Ruto, according to him, garnered 49.9%, Raila Odinga 48.3%, Wahiga 0.22%, and Wanjakoya 0.3%. It is on this basis that the sixth petitioner grounded the claim that none of the candidates met the constitutional threshold as set out in Article 138(4)(a). IEBC and its chairperson disputed the sixth petitioner's claim. They submitted that the declaration of results is based on the number of people identified as having voted on the KIMS kit and not the total persons on the voters' register as arranged. They contended that the final voter turnout, comprising of the voters who were identified through the KIMS kit and those who voted manually, was 64.76% and not 65.4% as arranged by the petitioners. They urged that the announcement error by the chairperson of IEBC on 10th August 2022 was immediately clarified during the same press briefing. And evidence of this correction was provided to this court in an affidavit of the first and second respondents in Presidential Election Petition number 7 of 2022. According to IEBC and the chairperson, 14,239,862 voters were identified using the KIMS kits, while 86,889 voters were identified using the printed voter register. Therefore, the total valid votes cast were 14,213,137, while the total number of rejected ballots were 113,614, constituting 14,326,751 total votes cast. They illustrated that the first respondent garnered 7.176141 votes against 14,213,137 total valid votes cast, yielding a percentage of 50.49 to meet the requisite constitutional threshold for a candidate to be declared president-elect. In the upshot, the percentage attained by each candidate was as follows: Raila Odinga 48.84%, William Ruto 50.48%, Waiga Mwaure 0.22%, and John Wanjakoya 0.43%. IEBC and its chairperson also submitted that the KIMS kits malfunctioned in 235 polling stations, necessitating the use of the printed voter register. In these polling stations, backup KIMS kits were later deployed for purposes of results transmission. The first respondent, in response to the question of 50+1 constitutional threshold, maintained that he attained the threshold under Article 138(4) of the Constitution as elaborated by the IEBC and the chairperson. This court has considered the differing formulas and threshold arguments presented by various parties to this petition, while the first, second, and third petitioners raised pertinent questions connected to this issue. We shall address them together with those of the sixth petitioner, who has addressed and focused on the issue as specifically framed in detail. It must be restated that the case made by the sixth petitioners concerns a data-specific threshold as enunciated under Article 138(4) of the Constitution, that without attainment of which there can be no declaration. This data-specific threshold is what this court declared in John Arun Mwau and two others versus IEBC and others. Petitions numbers 2 and 4 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IEBC, petition number 5, 3, and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% plus 1 of the votes cast in accordance with Article 138(4) of the Constitution. Similarly, in the same Raila 20, and this is what the court said, I quote, "In the case of data-specific electoral requirements, such as those specified in Article 138(4) of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt. The question that follows was whether the petitioners challenging the attainment of 50% plus one constitutional threshold and the computation by the sixth petitioner in general met the standard of proof settled by this court in Raila 2013 case. The premise of the sixth petitioner's percentage computation was a press briefing made by the chairperson of IEBC on 10th August 2022, when the evidential burden shifted to IEBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not include reports from all the Kim's kits and 86,889 voters who were identified manually using the printed register of voters. In our view, the assertion by the sixth petitioner that the percentage voter turnout was firstly predicated on the uncorrected percentage given by the chairperson of IEBC was negated by evidence adduced to prove the correction. Secondly, the sixth petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IEBC made reference in the press briefing to the number of registered voters who were identified through the Kim's kits progressively. The sixth petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional. We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IEBC and its chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through Kim's kits progressively and used by IEBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IEBC applied the formula in Article 138(4) of the Constitution, which is total votes cast less rejected votes divide by 2 must always give 50% plus 1 vote. Given the numbers that were presented to us by IEBC and the chairperson, this would translate to 14,213,137 divided by 2 plus 1, which makes 7.106569. The question that must inevitably follow is whether this formula, when applied, will confirm that 7,106,569 votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IEBC and its chairperson and the declaration by the chairperson of the president-elect on 15th August 2022, it is our finding that the declared president-elect attained 50% plus 1 of all the votes cast in accordance with Article 138(4) of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EU preparation by the INBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear and determine disputes relating to the election of the office of the President arising under Article 140. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the President-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the President-elect to be invalid, a fresh election shall be held within 60 days after the determination. In exercising its jurisdiction pursuant to these provisions, the court sits as an election court with a mandate to determine the validity or otherwise of the election of the President-elect. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders or reliefs it can grant following the hearing and determination of the election petition under Article 140 of the Constitution. In the event the court determines that the election of the President-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing INBC to hold a fresh election within 60 days after the determination. Should the court determine that the election of the President-elect is valid, it shall issue a declaration to that effect. The court has then, as a matter of course, to make an order dismissing the petition with or without cost, as the case may be. In the strict sense, therefore, these are the only orders that the court may make under the Constitution. The court cannot assume jurisdiction that goes beyond the purview of Articles 163(3) and 140 of the Constitution. However, nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the President-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the Amici Curie, and the court places a heavy premium on those briefs that were filed and those which were admitted. The final orders made by the courts. This is a unanimous decision of the court, and we make the following orders. 1, the presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as president-elect to be varied under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered. And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by counsel in these proceedings, and also the orderly way the counsel, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case. I think that is all. Thank you very much for coming.
My Lady, Madam Chief Justice, and the learned judges of this court, again, I am requested by my colleagues to thank you most profusely for your labors into delivering this judgment, listening to all of us, and giving our nation this judgment so that we may move forward. Thank you, and God bless you.
It may please the court. It is not true that I asked the Attorney General Emeritus to talk on our behalf. Next time you should talk to me. Let me similarly, on behalf of the lawyers for the counsel for the first and second petitioner, thank the court, and it has been a journey, worthwhile journey, sitting through these proceedings, and we thank the court for your patience and for the delivery of this judgment within the time stipulated. We thank you.
Madam President, members of the court, I wish to request just a couple of minutes for the chairperson of the Law Society of Kenya to make a few remarks in appreciation of the work that the court and Kenyans have done on this exercise, if you allow. Thank you. I call upon Mr. Eric Theuri to come and make his remarks. It is also his birthday. I would have sung happy birthday for him.
My Lord, the Chief Justice of the Republic of Kenya, the President of the Supreme Court, the Deputy Chief Justice, and all the justices of the Supreme Court, I think it would only be fair that I make my remarks after counsel for the respondents, Senior Fred Ngatia, makes his remarks to the court.
Madam Chief Justice, thank you very much. It's so kind for the President to acknowledge that age goes before youth. Mine is to thank the court, to thank my learned friends for the effort we all expended. We thank this court for clarifying certain issues, and we look forward to a less corrosive 2027. Thank you very much.
Madam Chief Justice, Madam Deputy Chief Justice, it's so nice to have two madams at the same time, and members of the court. Since there are only men talking, I decided that I should become a woman and talk. It's become too much of a male affair in here. But on behalf of well, I think we were the third petitioner, I wish to thank you, and you've clarified the Regulation 87.4, which I was feeling very passionately about, that it was unconstitutional from what I've heard. But thank you very much for the time you spent, and we do apologize if at times we looked like hooligans. I mean, you have said we behaved well, but we didn't behave as well as we should have. But thank you very much for your time and for delivering this judgment.
Madam Chief Justice, Madam Deputy Chief Justice, members of the court, I, on behalf of Attorney General, take this opportunity to thank you most sincerely for a great job done and for the courage to clearly define the limits of the law, which will help us empower IBC on the way forward, and hope that this might be the last of the petitions after elections once we carry out a proper elections based on your guidelines. Thank you.
The Chief Justice and the Justices of the Supreme Court, on a light note, my members would be extremely worried if we take the submissions of Senior Counsel Orengo that this should be the end on account of fees. But my lady, the Chief Justice, on behalf of the Law Society and all the members of the society, we wish to, first of all, take this opportunity to thank the court in the manner in which it has conducted these proceedings, extremely efficient, especially in light of the really short and strict timelines that you've had. But the management of the proceedings, the manner in which the court adopted a somewhat inquisitorial nature to the conduct of these proceedings is something that as a society we have noted, and we wish to commend the court. And we do hope that the other courts, as they determine any petitions, election petitions that will go before them, will similarly adopt such inquisitorial attitude, so that we try and really enrich the process that these proceedings intend to achieve. Secondly, I wish to also thank the council, all the advocates who have appeared before you. They have demonstrated extremely high standards of decorum and courtesy, and have also demonstrated a flair for persuasion of the court, including the use of PowerPoint, and of course the now famous Pinky Pinky Ponky mimic. But all that really, I'm sure, has demonstrated, especially to the younger members of the society, how to conduct themselves before the court and how to really prepare a persuasive brief. And we thank all the advocates who appeared before this court for the good work that they have done. And of course, as a society, we feel extremely proud that they have been able to raise the profile of the advocates in this country a notch higher from their presentation. So my lady and my lord, it's not lost to us that at the end of these proceedings, and once we are able to get your judgment after 21 days, that it is democracy and the Kenyan people who are the winners. The decision today, in a way, validates the choices that were made by the Kenyan people on on the 8th of August, and they also help to build confidence in the institutions that manage the elections and the court. We recognize that no country is born as a democracy, and that it is a process, and the process of challenging an election, as has happened before this court, is part of the processes of building confidence within the electoral system, and we thank all the petitioners for choosing to challenge the results before this court, but at the end of the day, Kenya stands tall as a beacon of democracy, and we're very grateful that we've had this opportunity also as a law society to appear before the court and to give an amicus brief which the court has had time to consider. So we thank you and we wish you a good day. I know it has been a long 14 days, but you can rest, and we'll be looking forward to the decision that you deliver within 21 days. Thank you so much, my lady and justices of the Supreme Court.
Thank you, Mr. President. I have been asked by the President of our court to react to your submissions, and in so doing, I am obliged to say that we are truly humbled by the statements that you have just made. More humbled because those statements come from both sides of the divide. And thank you for appreciating what we have to do within a very short while. Thank you for appreciating that it wasn't our wish that we were doing what we were doing. We were doing the wish of the Constitution of Kenya 2010, the laws of the Republic, the facts of the cases that you placed before us, and the evidence in rebuttal. We know that, and we have repeatedly said this, the President and I, whenever we have had time to talk to you in other fora, that we are incomplete without this side of the bar. We are incomplete without the advocates. We thank you. We will get opportunity to do that in the main judgment, in the reasoned judgment. But we really appreciate your industry. We were impressed by the submissions you took. And we were impressed, and we said this the last 3 days, I'll tell you something about that in a minute, by how deeply you believed in your clients' cases. That we think is a mark of an extremely grown legal profession, and we ask that you do not bring the bar down. You keep taking it up. In any contest of whatever nature, and even if we say there are no winners and losers, and even if we say that the winners are the Constitution and the people of Kenya, the truth is that some 6 million Kenyans will not be happy today. But that's the nature of the work we do. What we hope, and we hope you can advise your clients and our brothers and sisters that are the Kenyan people, that that is what was expected. One side had to win. One side had to be in total or a great extent of compliance with the Constitution and electoral law than the other side. That's how we saw it. We thank you very much. We, the 7 of us, have not slept since we parted company on Friday. I think it is showing on our faces. And we thank you that you appreciate that we work under difficult circumstances, especially because of time. As ground rules, we agreed when we left you here on Friday that we would not pick any of your calls. A lot of you called us, but we just couldn't pick your calls. And I hope you understand that we couldn't. We saw that you were trying to call us, but we just could not pick the calls. I hope you understand. And now if you allow us, again, on behalf of these 7 men and women, thank you very much for appreciating what we have to do. Thank you for giving us the honor to serve this country in these capacities. And let's hope that we can continue to grow our democracy this way. And thank you very much for everything you also do for the country. And now you allow us to go home and sleep.
Thank you. The court is adjourned.
My brother Kirago, I have a message for you.